Bom dia a todos, meu nome é Leonardo Nemer Caldeira Brant, eu presido o Centro de Direito Internacional com sede em Belo Horizonte. É com muita alegria que eu saúdo a todos os presentes, saúdo igualmente os professores internacionais e nacionais que irão estar conosco durante essas 2 semanas, durante o 16º curso de Direito Internacional. Eu gostaria de dizer que, em primeiro lugar, esse curso foi todo desenhado num novo modelo online. Nós já estamos aí no 16º curso desse gênero. Ele foi totalmente adaptado às novas circunstâncias, o que, de certa forma, permitiu também uma extensão do número de participantes, de professores internacionais e nacionais participantes. Temos este ano 19 grandes nomes do direito internacional que estarão presentes conosco durante essas 2 semanas. Num primeiro momento, portanto, eu gostaria de agradecer a todos os professores que colaboraram conosco, que estarão conosco nesse período, com palestras muito interessantes sobre temas dos mais variados do direito internacional. A todos eles, o meu muito obrigado. Em segundo lugar, saúdo e agradeço também aos alunos, aos estudantes que estão participando neste período de julho, conosco durante essas 2 semanas. O nosso também muito obrigado. Esse é um curso que envolve uma grande equipe do Centro de Direito Internacional, a qual eu tenho o imenso orgulho de colaborar e de presidir. Ele é um curso que pretende trazer para o Brasil e para a nossa América Latina o mesmo modelo de cursos que, de forma quase centenária, já é uma tradição nos países europeus e nas principais universidades do mundo. Portanto, para nós uma grande satisfação que tenhamos ele já há mais de uma década no Brasil. O curso de inverno de Direito Internacional, com toda a sua abrangência e extensão, não seria possível de ser realizado igualmente se não fosse a relevante parceria e a confiança e o apoio da Fundação Konrad Adenauer no Brasil. A ela estendo um caloroso agradecimento e tenho a certeza de que estamos contribuindo juntos para os valores do direito internacional, para os valores dos direitos humanos, para os valores do Estado Democrático de Direito, para os valores da democracia e, com certeza, para a compreensão e construção de um mundo, de um universo internacional mais justo e mais equilibrado. Portanto, agradeço de forma calorosa ao apoio da Fundação Konrad Adenauer no Brasil. Gostaria, portanto, de dar início ao 16º curso de inverno de Direito Internacional, esperando que todos tenhamos 2 semanas de muitas atividades e aprendizado. Um forte abraço a todos.
Okay, so hello everyone again. Good morning to those who are in Brazil. Good afternoon to Professor Tanzi, who is in Italy. Welcome back to the 16th winter program. My name is Amina, and I'm really honored to be introducing our speaker again today to all of you. Professor Tanzi today will talk about a completely different argument, and I'm sure by his personal, professional experience, he's going to contribute a lot to our studies on this topic. Professor Tanzi holds the chair for international law at the University of Bologna since 2006. He's an external scientific fellow for Max Planck Institute, Luxembourg for International, European, and Regulatory Procedural Law. He was a visiting professor at University of Vienna and also an enseigné invité at Université Paris de Panthéon-Assas. He's a member of the Permanent Court of Arbitration. He's a conciliator at the Court of Conciliation and Arbitration for the Organization for Security and Cooperation in Europe, chairman of the Implementation Committee of the UNECE Water Convention, and legal consultant to Italy's Minister of Foreign Affairs. On several occasions, Professor Tanzi was a member of Italy's delegation to the 6th Committee of the UN General Assembly. Professor Tanzi as well is the author of a number of books, including International Investment Law and Arbitration, Introduzione al Diritto Internazionale Contemporaneo, The Consolidation of International Water Law, a comparative analysis of the UN and UNECE water conventions, and a concise introduction to international law. His lecture today will be about a common but differentiated law of international adjudication. This is a very interesting topic in its procedural point of view, but also in its substantive point of view. For instance, I recommend our students to read Professor Tanzi's articles about international adjudication with special regard to investment arbitration. Some authors, they talk about a second generation of international tribunals, right, Professor, referring to international commercial and investment tribunals. So Professor Tanzi has also many articles and lectures about Latin American arbitration, especially regarding energy industry. So it's a very interesting and exciting and rich argument. We are happy to have you here sharing with us your knowledge and experience on that. I'll pass it on to Professor Tanzi. Thank you and welcome back.
Thank you very, very much. Amina, can you hear me?
Yes.
Good. Just a minor technical announcement I have to make. Since I'm sitting currently in a number of investor state arbitration proceedings, I will make general statements to the effect that none of my statements may prejudice my impartiality and freedom to apply on a case-by-case basis the general principles and rules that I am going to discuss and share with our audience today. And thank you very much for a very generous introduction once again, as good as yesterday's and very generous. Thank you very much, Amina. Well, today, as you said, I'm going to address a completely different topic. It seems as if yesterday we were sort of discussing the chief systems of international law and society, whereas today we're going to address something rather peculiar, detailed, and technical. As a matter of fact, at the end of my lecture, I'll be very happy to take any questions concerning today's lecture, again, about yesterday's or any other topic of international law, including the health emergency that we are all going through around the globe. If you were to find today's lecture a little bit too technical, but in fact, my first statement today is precisely why focusing on such an apparently highly specialized technical topic. Well, in fact, I believe that international litigation is absolutely becoming more and more of a topical, overarching issue. Procedural law and the law of adjudication, we are going to see the differences in a moment, apply to human rights courts, interstate adjudication, investor state, WTO disputes, law of the sea disputes, and that will turn out to be very, very, very useful, if only for the fact that if we consider that international adjudication is a pretty recent phenomenon, if we consider modern international law based on the Westphalian model, as we said yesterday, centuries ago, the first permanent international body was established only 98 years ago. It will be in 2022 that we'll celebrate the centennial of its creation. Therefore, and you consider that the largest majority of existing adjudicative bodies have been set up long after the Second World War. So it's a fairly recent body of international law. We'll see the International Criminal Court having been established only a few years ago. The EATLAs having been established only in 1990, well, with the Montego Bay Convention, and started operating in 1996. So it is only natural that international procedural law and international law of adjudication is very much on the developing stage, and it is absolutely worthy focusing on it. Let me make a few references on the formidable degree of increase of use in international law of adjudicative means of dispute settlement. It seems a little bit of a paradox at a time in which multilateralism is in an apparent crisis. States go unilaterally, that you still have increasing resort to international third-party adjudicative bodies. Let me refer to the establishment, for example, of the Central American Court of Justice in 1991. The ECOWAS Community Court of Justice. ECOWAS is the Economic Commission for West African States. Well, it was established in 1991. And it was established on paper in 1991, but was set up in the year 2000 and became functional the year later. 1992, the Economic Court for the Commonwealth of Independent States in Eastern Europe. COMESA, Court of Justice. COMESA, the Court of the Common Market for Eastern and Southern Africa, set up, well, provided for in 1994. And its composition was completed in 1998, and we'll see the numbers of actual work pressure on those adjudicative bodies, but that's not the end of the list. We have the European Free Trade Association Court, provided for in 1994. In the same year, we had, as I mentioned before, well, 2 years later, the inauguration of the International Tribunal for the Law of the Sea. I, as a practicing lawyer, haven't had the pleasure to be involved in international law of the sea proceedings, when over the last 3 years I happened to appear before the International Tribunal for the Law of the Sea quite a number of times in 2 different cases. And that is telling. Then you have in 1998 the Common Court of Justice and Arbitration of the Organization for the Harmonization in Africa of Business Law. That's quite an impressive host of developments. In the year 2000, the East African Court of Justice. 2001, the Caribbean Court of Justice was set up. In 2004, the African Court of Human and People's Rights. And then you have, in 2005, the first provision, and then in 2012, amendments to the SADC Tribunal, SADC, which stands for Southern African Development Community. You would say, well, these are developments on paper, but have they been working? Have they received the confidence by states to settle their disputes? Let me give you a few data to understand the terrific development of international adjudication. Let me take, for example, since we are in Latin America, the Central American Court of Justice, Corte Centroamericana de Justicia. Well, between 1990 and 1994, for 4 years, it has been all sitting on its hands, having just one contentious case. But between 1995 and 1999, it has been dealing with 13 cases, whereas between 2000 and 2004, 33 cases have been brought to it. Between 2005 and 2009, new 17 cases have been introduced before contentious cases have been submitted to it. And between 2010 and 2014, 34 contentious cases have been brought before it, and since 2015, 25 new cases have been filed with the court. But you have to add also its advisory jurisdiction. It has been seized with requests for advisory opinions up to 12 between 1995 and 1999. New 9 requests for advisory opinion between 2000 and 2004. New 12 new requests between 2005 and 2009. 15 between 2010 and 2014. New 17 new requests for advisory opinions since 2015 up to now. Just one example. The Permanent Court of Arbitration, since I've been introduced as a member of the court, I'm actually a member of the Italian national group and also part of the list of arbitrators concerning environmental law disputes and disputes on natural resources. The Permanent Court, despite its name, is not a court. It's an international organization, an institution which administers arbitrations, and it was sort of again sitting on its hands. I mean, you have a roster of arbitrators. They can be chosen. No case has been filed before the PCA or tribunal that would be established within the framework of the PCA between 1990 and 1994. You only had 2 cases between 1995 and 1999. And then all of a sudden, you had 13 cases in 4 years between 2000 and 2004, 16 between 2005 and 2009, 45 cases between 2010 and 2014, and between 2015 up to now, 59 new cases have been filed. And that is quite impressive. You have interstate arbitration cases administered by the PCA, so far 40 cases. Investor-state arbitration disputes, 128. You also have private commercial international arbitration being administered by the PCA, 48 cases. You also have conciliation cases and other kinds of proceedings, including mediation. Not to mention that the PCA Secretary General has been acting as an appointing authority for ad hoc arbitration proceedings only between 2011 and 2019, 441 times. Well, those are telling figures, but you may ask about what the mother of all adjudicative institutions, the International Court of Justice. Well, between 1990 and 1994, you had 12 cases. Between 95 and 99, you had 26 cases. 12 between 2000 and 2004. And since 2015 up to date, you have 17 cases. You probably are aware of the filing by the government of the Gambia in November 2019 against Myanmar for the alleged commission of an act of genocide against the Rohingya population. Just to mention the last case, I don't like numbers very much, but then I know that particularly in the Latin American continent, the CIADI, ICSID, is very much debated nowadays. Investor-state disputes. There's much debate about reforming the system, crossfire against these kinds of proceedings, means of settlement, dispute settlement, but nonetheless, the line is very much on the increase. You had 6 cases between 1990 and 1994, and currently, I mean, between 2015 and 2019, 234 cases have been filed before ICSID arbitration tribunals. So you have quite a thriving landscape about international adjudication and arbitration. It is therefore important that the law of international adjudication is familiarized with by a wider number of members of the community of legal scholars and practitioners. I mean, and I'm also referring to those lawyers who aim at a domestic practice, a future career of domestic practice, where you really want to be able to recognize the international law factor in any potential or actual dispute in order to enhance the chances of legal defense of your client. In one of my studies, I have underlined how much a corporate lawyer working at home, particularly in Latin America, in the field of energy, mining, may be very much under pressure to follow the international substantive law and procedural law processes in order to best advise his or her client, even with regard to interstate disputes. What about having a concession contract with a state over resources that are located in a disputed area? Or when perhaps the technical, logistical, scientific, technological processes of the economic activity of your client might be at variance with international legal standards to the extent that there might be an interstate dispute. Take, for example, the Argentina-Uruguay case before the International Court of Justice, the pulp mill case. Eventually, the case was settled, the court finding for the respondent state. But had it been differently, the private investors would have had quite a business problem linked very much to legal considerations, and the procedural side of the whole process would have been of great interest for the corporate lawyers in order to best advise the company. So those of you who want to engage in a career with the office of the Attorney General or Solicitor General, depends on the constitutional setting of each country, whether you want to join the Foreign Service with special regard to the legal office, but not necessarily the legal directorate, but also if you are a simple diplomat, admissibility issues of jurisdiction, potentials for going before an international adjudicative body are part and parcel of the political diplomatic process that will require political diplomatic decisions, cost-benefit analysis of going on with negotiations, or whether negotiations can be promoted, paradoxically, by resorting to international adjudication. So many a case prove that adjudication is not necessarily alternative to diplomatic means of settlement. Many a time, the International Court of Justice or other ad hoc adjudicative bodies have invited the parties to negotiate parts of the disputes or the entirety of the dispute. But certainly the factor of having resorted to the international adjudicative body may add to the determinants of the negotiations at any given point in time. In any case, as the international law philosopher Professor Samantha Besson observed, and I quote, "Current international law can no longer be understood without its judicial dimension," unquote. And this is testified by an incredible number of new editorial initiatives, Encyclopedia of International Procedural Law, international journals focused on adjudication, the law and practice of international courts and tribunals, the Journal of International Dispute Settlement, just to mention two. Now, in the legal literature, the functioning of international courts and tribunals has been conceived, and I am now going to explain the sense of my title, the title of my lecture this morning. The functioning of international courts and tribunals have been conceived to fall within some kind of at least emerging, if not consolidated, common law of international adjudication. Professor Chester Brown from Australia, learned lawyer and practitioner, wrote a book in 2008, published by Oxford University Press, precisely titled A Common Law of International Adjudication. And I have much sympathy for this approach, which accounts for the first part of the title of today's lecture, the common side, a common procedural regulatory framework governing the conduct of different adjudicative forums seems to be increasingly corroborated by examples of cross-fertilization, an expression coined by Professor Philippe Sands, between different forms of international litigation, possibly and even though partly including even international commercial arbitration to some extent. As Professor Yuval Shani emphasized, indeed, and I quote, "International adjudication has developed through a process of replication and adaptation," unquote. Now, the adaptation factor accounts for some degree of differentiation, but differentiation according to which standards? That is what I'm trying to address today. But there is a basic distinction that I would like to draw from the outset. And you probably have been a little bit already brought to guess that sometimes I use the expression international law of adjudication, and sometimes they refer to international procedural law. Now, I would like to make a distinction between procedural law in terms of the law encompassing the rules and principles that regulate the conduct of proceedings. And I will elaborate further on this. On the one hand, and the law of international adjudication comprising the rules and principles which govern the deliberation process of an adjudicative body. One thing is to govern the conduct of proceedings, the relationship between the parties themselves, and the relationship between the parties and the adjudicative body. But when it comes to deciding the case, you have other principles, and those are principles that are addressed to the tribunal exclusively with regard to its core function of deciding the case. Those are non liquid, ne infra petita, ne ultra petita, iura novit curia. I mean, you have been submitted a case, you are not supposed not to decide the case. But you cannot decide the case going beyond what you have been asked to decide, ne ultra petita. And you cannot fall short of deciding what you have been asked to decide. And then the big issue of iura novit curia, which I was supposed to discuss at the Hague Academy this summer, I suppose these days, or probably next week, but it has been put off by 1 year. Iura novit curia is an international tribunal constrained to use only the legal arguments which have been submitted by the parties, or may decide according to legal arguments other than those submitted by the parties. Those are clearly rules and principles that pertain purely to the deliberation process. Now, let me first address procedural rules and principles governing the conduct of proceedings, where I see a rather overarching commonality of principles. There is indeed, I believe, a truly common procedural law which is emerging, consolidating, even though we have seen that we have fairly new, fresh, green international adjudicative bodies. I was referring to the rules on actual institution of proceedings. You have ordinary proceedings or incidental proceedings. You have proceedings concerning provisional measures, preliminary objections, counterclaims, special proceedings. You have before the International Tribunal for the Law of the Sea prompt release proceedings. You have a tanker which has been seized, and before you have the settlement of any dispute, which may take years, you have prompt release procedure that may be even filed by a non-state actor as for the trigger. Then you have rules on the filing of the case, filing of objections, actually on the requirements for the validity and admissibility and validity of the actual filing of the case of objections. You have rules on the submission, procedural rules on how to submit written and oral pleadings. Obviously on the burden of proof, production of evidence. You can have evidence through the production of documents, written documents, or witnesses, cross-examination. Then you have rules on intervention, the admissibility of intervention by non-parties, on the suspension or discontinuance of proceedings. This is what I regard the body of and not only I regard, it's absolutely generally agreed that this is procedural law. And there, let me give you an example of an extreme case of cross-fertilization, which accounts for the fact that there is a common ground from which you can take bits and pieces of precedents, of practice from one sector, cluster of international adjudication or arbitration, and apply it in a different one, which accounts for the common nature of those principles. Let me take the example of a case in which I was lead counsel before the Hitlers. Panama sued Italy for the alleged illegality of the seizure of a tanker back 20 years before, actually 15 years before the actual filing of the case. Panama submitted a request for a rather generic production of documents to Italy. Actually, the claimant asked the respondent to produce the dossier of the whole criminal case before the Italian criminal courts. The tanker had been seized because it was suspected of being used in tax evasions and other criminal conduct under Italian domestic law. Panama asked the file in possession of the Ministry for Foreign Affairs and the Ministry of Justice. In fact, we had just in a remote area of a rather provincial tribunal, a paper file which had few documents. Otherwise, in the ministries, more than 15 years having passed, there was no possibility to retrace the documents. But even irrespective of whether Italy was in the possession of the documentations, Italy objected that a request for disclosure of documents had to be precise and punctual and could not refer generically to the entirety of a party's file. Panama reacted, saying that by indicating the dossier concerning that specific case before the domestic courts of Italy, its request was specific and that it precisely identified the files, the whole file. Now, the problem was that the rules of procedure of Hitlers would not regulate the matter in so many details about production of evidence. Therefore, Italy grounded its objection in its further reply, relying on the IBA rules on the taking of evidence in international arbitration. Now, the IBA rules on the taking of evidence in international arbitration, which is mostly, they were conceived for international commercial arbitration, are not a source of international law, nor a source of any domestic law as such. They are so-called soft law by an authoritative non-governmental body. And but we thought that they were quite authoritative, if only for the fact that they had been applied recurrently, consistently by international commercial arbitrations and arbitral tribunals. And let me mention Article 3A and B of those rules. It provides that the requests to produce documents have to contain a description of each requested document sufficient to identify it, or a description in sufficient detail of a narrow and specific requested category of documents that are reasonably believed to exist. A statement as to how the documents requested are relevant to the case. Obviously, there was no such degree of precision, and eventually the tribunal decided that it could not accept Panama's request without making any reference to whatever authority, no rules of procedure. It did not refer to the IBA rules, but clearly it took into account the arguments put forward by the party, the respondent, for which it found in that particular instance. And the arguments put forward by Italy were relying precisely on practice, basically, concerning another body of international arbitration. Now, among the general procedural rules, a key procedural regulatory pillar is the principle of the equality of arms. Now, when the rules of procedure of any given arbitral tribunal or adjudicative body lack precision or express regulation, you may rely on the principle of the equality of arms. So if a party submits documentation, you have to give the other party the chance to express its comments and its views, so that the decision will eventually be based on having heard both parties equally, affording them the equality of arms. But the mother or father of all general principles of procedural law is that of inherent powers, with the variation of implied power doctrine. Here again, I can make the case that its scope of application is confined to the conduct of proceedings and procedural powers without stretching to the extent of governing the deliberative powers of any given adjudicative body. One exception, in the sense that inherent or implied powers may stretch to the deliberative process, it is with regard to the process of deliberation as to whether a given adjudicative body has jurisdiction over a given case motu proprio, ex officio, that is to say, irrespective of preliminary objections having been raised by the parties. That is generally considered to be an inherent power of the tribunal. But that does not really contradict my point, in the sense that in the end, that deliberative process falls short of the actual decision on the merits of the case. If you want to know about the matrix of the statement of inherent powers, not just through my words, but through the authoritative words of the Permanent Court of International Justice from Mavromati's case between Greece and the United Kingdom in 1924, the court observed about the power to address an objection being raised in limine litis. The court found that, and I quote, "The court is entitled to adopt a principle which it considers best calculated to ensure the administration of justice, which is most suited to procedure before an international tribunal and most in conformity with the fundamental principles of international law." It's just free to do that. In the nuclear tests case, the International Court of Justice observed as follows: inherent jurisdiction on the basis of which the court is fully empowered to make whatever findings may be necessary for the purposes of deciding based on the mere existence of the court as a judicial organ established by the consent of states, and it is conferred upon it in order that its basic judicial functions may be safeguarded, unquote. That is to say that a tribunal or a court may not be blocked on any particular issue because there is no specific procedural regulation. By its very adjudicative nature, it is to be considered to resort to any inherent power that allows it to perform the functions it has been vested with by the parties when you have an interstate or an investor state kind of case. Precisely, let me get to an investor state case, the Bananco, 2008. The ICSID tribunal observed, and I quote, that it does not doubt for a moment that, like in any other international tribunal, so it puts itself on a par with any international tribunal. And I continue. It must be regarded as endowed with the inherent powers required to preserve the integrity of its own process. End of quotation. So the inherent powers doctrine seems to be the magic formula that provides legal justification for the exercise of all the powers that an adjudicative body deems necessary for it to exercise its functions. Now, let me argue and substantiate my statement whereby this principle applies to strictly procedural issues and competence, but not to the deliberative powers on the merits. Now, Chester Brown made a comparative analysis of different international courts and tribunals on the issue of inherent powers, and it came down to the following statement, and I quote, "A significant body of practice demonstrates that international courts are not restricted to exercising the procedural powers which are conferred by their constitutive instruments, but can also exercise inherent powers," and he adds, "so long as applicable restrictions on their use are respected." End of quotation. And the big issue is, what are the applicable restrictions on their use? Now, the restrictions applicable to the powers in question, I would say, are precisely those determined by the general principles governing the deliberation powers of any given international adjudicative body. In fact, Chester Brown conceded that his very generous conclusion about a very extensive approach to concerning the scope of application of inherent powers, in the end, it is restricted by precisely applicable restrictions. But then he said, this depends on the fact that, and I quote, "the exercise of such powers usually relate to procedural issues rather than the end game of international proceedings," unquote. What is the end game? What are the aspects that pertain to the end game of international proceedings? Precisely the actual decision-making process. And Martins Paparizis, who also wrote about inherent powers, in which he follows a rather broad and extensive approach, in the end, he also seems to go down the route of referring in extensive terms to specific procedural powers. I quote, "In particular, the power to grant binding provisional measures, power to deal with the abuse of process, power to deal with evidence, power to order remedies, and power to come to the annulment that applies to annulment committees." And then you have the exception that, yes, the inherent powers of international adjudicative bodies covers the decision about whether a given international court or arbitration tribunal has the power to decide on its own competence. It's a famous competence principle. Well, in the interest of time, I cannot go deep into this. Those of you who may attend next year, hopefully in person, the Hague lectures, maybe we'll have the chance to discuss this for a longer period. But let me give you a little bit more of an example of what I believe to be these magic principles of deliberation. Non-liquid. Non-liquid means not clear. According to this principle, a tribunal should not abstain from deciding a case on the merits, provided it has jurisdiction, provided the competence power has been exercised. The risk of non-liquid would arise. When would it arise? When the disputed facts submitted by the parties are not clear enough for the adjudicator to identify the rules which may settle the dispute, or when the adjudicator cannot find the rule that governs the facts in question, or when the governing rule is not clear enough in relation to the disputed facts. I link this non-liquid principle with the Jura Novit Curia principle. What is it that the rule is not clear enough? Is it not clear enough because it has not been pleaded well enough by the parties? Should the court come up with a better argument and decide the case? But the answer is yes. Here you apply Jura Novit Curia. As the great international lawyer and arbitrator Jan Paulsen observed, an international court or tribunal is not bound to choose for the least weak of the arguments of the two parties. So if you had bad counsel, you're not bound to have a bad decision or have a non-decision because the counsel have not been good enough to make their own case. And therefore reject, basically, not decide the case. But the parties, actually the claimant usually, but also the respondent, have made the case in terms of claims. One claims that there has been a breach, the other claims that there has not been a breach, and you are duty bound, according to the combination of those legal rules and principles on deliberation, to decide the case, linking up non-liquids with Jura Novit Curia, but then mixing it up with two other ancillary principles. You have to decide the case as it has been brought to you. You cannot decide anything more than it has been submitted to you, ne ultra petita, nor can you, or should you, or you are allowed to decide anything less than you have been requested to decide upon. Within that framework, and within the framework of the jurisdictional power to apply the applicable law, which in interstate adjudication and in investor state adjudication and in international commercial arbitration, the applicable law is decided by the disputing parties. Well, you have Article 38 for the International Court of Justice, that tells you what is the applicable law, you may think, but in fact, within the broad scope of Article 38, the applicable law is, on each particular case, is the law which is being accepted by the parties that it will be the applicable law on a case-by-case basis. You probably remember the famous Nicaragua-United States case about military and paramilitary activities decided by the court in 1986. The ICJ was bound by the consent to the jurisdiction by the United States, according to which it could not apply multilateral treaty law unless all the parties to the multilateral treaty were parties to the dispute. Basically, the United States did not accept the jurisdiction for the court to apply the Charter of the United Nations with regard to Article 2, Paragraph 4. That is why the International Court of Justice decided the case based exclusively on customary law. So within those boundaries, an international adjudicative body may decide. Now, you say, but why is Professor Tanzi then making such a difference between procedural rules concerning the conduct of proceedings and other technical issues on the one hand, and the general principles on deliberation? So far, he has been making general statements which seem to be, I hope, pretty reasonable, that would apply to any international courts and tribunals. Well, in fact, and here comes the differentiation, the general principles on deliberation, namely the combination between them, is modulated, is calibrated, is differentiated according to different clusters of international adjudication. Which are the clusters of international adjudication that I am referring to? And on the basis of which principle and factors do you make up such a distinction? Now, I argue that there are three basic clusters of international adjudication: interstate and investor-state litigation on the one hand. Second cluster, human rights litigation. Lastly, international criminal proceedings. You may have further modulations within each such cluster, but they basically respect three different kinds of international adjudication. Based on what? Based on the combination of the application of the basic two-prong adjudicative function. Two-prong in what respect? Deciding the case, settling the dispute, one. Two, interpreting and applying, and to an extent possibly developing the law. Let's set aside the development of the law, which could stand as a separate topic. You have to decide the case, and then you have to apply the law. Now, in interstate adjudication, as much as in investor-state adjudication, the mandate is afforded to the tribunal, is bestowed to the tribunal by the parties. The autonomy of the party there has a strong hold on the actual adjudicative function of either the International Court of Justice, the ITLAs, an interstate arbitration tribunal, as much as an investor-state tribunal, or a commercial law tribunal to a large extent. So there, the tribunal or the International Court of Justice is to apply the law strictly within the boundaries necessary for it to settle the dispute which has been submitted to it by the parties, and is to apply the law strictly for that ad hoc purpose. I wouldn't go as far as to say that between the two pillars of the function, applying the law and settling the dispute, the actual settlement of the dispute is more important rather than the application of the law. And do not confuse general statements about the law and the development of the law that is being made wonderfully by the International Court of Justice or the ICLOS or some kind of wonderful interstate or investor-state arbitration tribunal. I am focusing for the application of these general principles rules on the ratio decidendi, the reasoning of the court which is strictly necessary for the settlement of the dispute. Obiter dicta consideration fall outside the scope of the constraints of the application of this principle. Take the Barcelona traction case. We all know about it, don't we? That is the first serious authoritative adjudicative statement about erga omnes obligations. But what did erga omnes obligations have to do with the case brought first by Canada, then by Belgium against Spain for purposes of settling a dispute about basically expropriation of the electricity sector? In fact, the court said, we are not in a situation of application of erga omnes, but it wanted to develop the law outside the ratio decidendi. The court was not addressing the issue for purposes of deciding the case. So in interstate, investor state, the disputing parties are largely the masters of the power of the tribunal or the court is to apply the law and can develop arguments that go beyond those counsel strictly to the extent of settling the dispute, but absolutely within the configuration of the dispute as it has been submitted to it by the parties, the common ground of the position of the parties within the scope of the applicable law. Now, in human rights litigation, yes, you have common law of procedural law whereby you have to apply the equality of arms between the applicant and the respondent state. The rules on production of evidence are the same. But if counsel for applicant, the recurrent, is poor, the facts submitted to the court seem to be falling within the scope of application of X numbers of articles, protecting X numbers of rights, but counsel only pleads 1 or 2 out of 5 relevant rights and provisions encompassing such fundamental rights. Now, the Human Rights Court in question is not bound by the consent of the parties which mandated the court. The mandate comes from the state's parties as a whole, and the court applies the applicable law, which is the Human Rights Convention in question, as a piece of constitutional law of which the court itself is a guardian. Now, apart from the imagination and legal reasoning of Professor Tanzi, let's go to the actual black letter message that comes from positive case law. Many times, the Inter-American Court of Human Rights and even the European Court of Human Rights has recharacterized the claim submitted by the claimant, by the applicant. Of course, based on the facts submitted to me by the recurrent, the applicant, the applicable provisions are much more than those that have been infringed upon by claimant. So the court has recharacterized, so it has stretched the principle iure novit curia to the extent of going even beyond the principle ne ultra petita. It was not asked of by the applicant. Why that? Because the court is not to apply the law which has been agreed upon by the disputing parties, is to apply the convention as a normative pillar of which the court is the guardian, and is to refine, to protect, to safeguard the core normative body in question. And this is corroborated even by cases in which the claimant has passed away, there were no heirs, so there was no longer a dispute standing before it, pending before it. So here again, the function of application of the law is prevalent with respect to settling of the dispute. The dispute was no longer there, but the court applied the law because it was very important to perform its function as the guardian of the applicable law, the Human Rights Convention in question. Now, lastly, the third cluster is international criminal law, the proceedings before the former tribunal for the Tribunal for the Crimes Committed in the former Yugoslavia, the International Criminal Court. We are within the sphere of criminal proceedings where, apart from the procedural guarantees, which very much tend to put the accused within the scope of procedural guarantees of both parties, and you can also speak of the equality of arms within criminal proceedings, and that is where you have some degree of the utmost degree of commonality, but you have a differentiated application of the principles iure novit curia, ne ultra petita, and the rest of it, because there again, public prosecutor and the judge and the case in itself falls within the scope of public interest. So when two states are disputing before the International Court of Justice, the application of the law as a public interest, as much as we speak about the application of public international law to the dispute, is subservient to the actual settlement of the dispute. I'm not sure I'm very happy about this statement as a matter of principle, but as a matter of principle, which is corroborated by the fact that any ICJ dispute, settlement, judgment is legally binding for the parties only. So there is very much of a civil procedural law approach even before the International Court of Justice, which I very much regard as basically arbitral in nature, because it operates, it exercises its jurisdiction as a matter of consent by the parties, as much as you have consent as a constituent element of the jurisdiction of an arbitral tribunal in domestic legal systems. I hope I haven't overwhelmed you with technical considerations, and I will, Amina, stop here, and I'm very happy to try and answer questions that may come from the floor. Thank you very much for bearing with this class, and for your time.
Thank you, Professor. That was very, very interesting. There are a few technical questions over here as well. There is a student asking about the sandbagging clause. It says, in the matter of international arbitration, what are your thoughts regarding to the legality of a sandbagging clause?
Oh, which kind of clause, sorry?
Sandbagging. I guess it's it refers to like the investor that sometimes try to hide things in order to sound like weaker in an investment agreement. I think it refers to this kind of, if the student...
I see. Well, I'm terribly sorry to have to shy away from this question. I mean, I hope you understand, based on my statement I made at the beginning, this is a very good question. Mm-hmm. This is one which indeed would deserve, let me say that one would resort to some general principles which would come to the rescue of the arbitration tribunal, but on the case-by-case basis, good faith, clean hands would apply, but also the question of ne infra petita, a combination of considerations, the good faith by the investor, the claimant, but I cannot express any view outside any specific case, and I don't want to make any hypothetical, because tomorrow I could be asked to
Sure.
arbitrate in a case where the actual disputed facts correspond to the hypothetical that I may submit now to you, and
Sure,
then I would incur an issue conflict. So I'm sorry, but I do that for professional scruple, also for future potential parties that have to be impartial, and I cannot prejudice my future consideration.
As a matter of fact, a few students were asking also in the beginning about how is to have all these roles, right? Like, you are a university professor, you are a lawyer, and sometimes you act as well in this kind of proceedings. So I think right now we just had a very practical...
Well, let me tell you, Mina, that is a good question, because after all, teachers, I still regard myself as a young man, but I understand that much water has passed under the bridge since I was a student. But it's good that I can share with young students and scholars and practitioners my experience. And indeed, I would say that my professional role has certainly benefited a lot from methodology of research. I mean, when I am counsel in interstate litigation, as much as sitting as an arbitrator, I mean, looking at case law, legal literature, the combination of the two, the methodology, I mean, some kind of compulsive, obsessive attitude towards research is good. It helps. Mm-hmm. It makes you a good practitioner, a good counsel, and a good arbitrator, I suppose. But at the same time, I have been enriched a great deal in my teaching and research activity by my professional experience. I mean, first it was a legal diplomatic experience, going to the 6th Committee of the United Nations, preparing the dossier. I mean, you realize what really, at any given point in history, the United Nations is all about. I have written a lot about soft law, and that was thanks to my experience in New York. That helped me a great deal. So I could merge the outcome of my experience in practice with my research. Why have I been talking to you today about international procedural law? I did not study much procedural law except for my first book on jurisdictional immunities. I studied domestic procedural law, criminal and civil, but in international adjudication, I wasn't particularly versed with it until practicing, I realized that the same issues would arise. And one day I asked myself, can such arguments deserve integration? And that is how I came to realize the importance of Iura Novit Curia, and I wanted to learn more about it. By learning more about it, based on the exigencies of my profession as an arbitrator, I realized that that was a topic worthy researching as a scholar. So I think that my scholarly activity benefits from my practice, and my practice benefits from my scholarly background. One last remark is, among the various hats, I am happily a counsel in interstate litigation. And as much as you still have many arbitrators who also practice as counsel in investor-state arbitration, I've tried so far so far I haven't acted as counsel in investor-state arbitration, because precisely for the same reason I was explaining that I wasn't happy to answer in concrete terms to that question. You cannot plead for a party, be it a claimant or a state, before an arbitration tribunal today, and tomorrow decide impartially on the same, apply the same principles that you've been pleading in a case that might be similar. So, and I think that in the future, the trend is going in the direction of preventing double hatting. You cannot act as counsel and as an arbitrator.
Okay, thank you. I think we have time for a few, maybe a couple of questions still. Someone is asking the difference between the non-ultra petita and the estoppel.
And estoppel.
Yes.
Right. Estoppel is a principle which applies rather dynamically between the parties. It may curb the right to invoke something which has been contradicted by your own conduct. I think that the tribunal is not itself bound by estoppel, which is something which applies to actually the parties. The tribunal can apply estoppel in its decision-making with regard to the conduct of the parties. But it itself is bound by some principle of consistency, first in its obligation to state reasons, and the lack of reasoning, for example, is a ground for annulment before ICSID annulment committees. And it is a principle of fairness of international adjudication. It's in the essence of the adjudicative function that the tribunal is to follow a consistent line of reasoning. And I would very much regard this principle to be supported by ne infra petita, ne ultra petita, Iura Novit Curia, and respect of its mandate. Mandates change, as we have seen. The mandate of the European Court or the Inter-American Court of Human Rights is a mandate which is different from the one that comes from the parties before the International Court of Justice or has been endowed to an international investor state tribunal. So all these principles aim and go in the direction of the consistency and compliance with the rule of law and the principle of fairness of adjudication, fair trial, and due process. Whereas estoppel applies more to parties.
Okay. One last consideration, Professor, relating to in your experience, right? Do you think it's easier to make these kind of decisions from arbitral jurisdictions more enforceable than in ordinary jurisdictions? Like, are states more likely to actually respect these arbitral sentences? In your experience, what do you see? Because I think that's a very, it's a question that is on our minds when we study the international jurisdiction. So is there actually a difference between international adjudication in this sense?
That's a very good question. So structurally, I have already expressed the view that even permanent adjudicative bodies such as the International Court of Justice and partly the ECLUS. I mean, let's say something separate about the ECLUS. The International Court of Justice can exercise its jurisdiction, I would say, very much on an arbitral basis, in the sense that it has no jurisdiction unless the parties have submitted their will to be submitted to the jurisdiction of the court. And the applicable law depends on the will of the parties. Obviously, I mean, you have jurisdictional clauses in international treaties. We call them jurisdictional clauses and are separate from arbitral clauses, but they stand very much like arbitral clauses because parties can adjust the applicable law. In a private law contract, you can really distinguish between a jurisdictional clause, you afford jurisdiction to the tribunal of that state, that city, which will apply the law of that country, period, or will apply the law, the private international law rules of that country, period. But, or else you decide to afford jurisdiction to an arbitral tribunal, which will follow may follow different considerations, including the applicable law. Now, the International Court of Justice is largely arbitrary in nature. The ECLUS is interesting because the ECLUS and paradoxically, ECLUS renders Annex 7 arbitration tribunals closer to a permanent body, adjudicative body of the kind that we are used to consider in domestic legislation, because the UNCLOS provides for compulsory jurisdiction. There is no opting out. You can opt out about the ECLUS, say, I don't want the ECLUS, I don't want the International Court of Justice. So if the party ratifying the law of the Sea Convention doesn't expressly indicates that it accepts the ECLUS jurisdiction or the ICJ jurisdiction, you by default are duty bound to take part in an Annex 7 arbitration proceeding. And in that respect, you have a sort of compulsory jurisdiction, which is also based on the will of the state, which has decided to accept it by becoming a party to the ECLUS, but it's stronger in that respect. And in fact, we have witnessed cases in which, and then I will get very shortly to the issue of execution, cases in which the respondent party, China, in an Annex 7 arbitration, has not appeared before an arbitration tribunal. It is happening with Russia also, but in other cases, including investor states, but it is more unlikely that you have proceedings in absentia before arbitration tribunals because the consent of the parties is less remote. But in law of the sea context, based on the jurisdictional provisions of the UNCLOS, well, there it is more likely that the defendant state is recalcitrant, and that will then indicate the possibility that the defendant, if condemned by either an Annex 7 tribunal or ITLOS, will not spontaneously comply with the execution, with the judgment or the award, as much as we have seen it also with regard to judgments by the International Court of Justice. My country, for one, despite my government in 2013 with regard to the Germany-Italy case, which upheld jurisdictional immunity, sovereign immunity of Germany, had passed legislation to comply with the decision. So when the parliament and government had passed legislation to enforce the ICJ judgment. But then a domestic judge resorted to the Constitutional Court saying, is this law basically incorporating the ICJ judgment compatible with the Constitution? And the bizarre decision came from the Constitutional Court saying that it was not compatible. So it was a clear case of non-execution, rejection of the execution of the ICJ judgment. And as an Italian and as an international lawyer, I felt very, very unhappy about it. But I have to admit that is an element of practice of non-compliance.
That's perfect. Amazing answer. Thank you very much, Professor Tanzi. All the students are thanking you here as well. We had almost 300 people watching us now. So thank you very much for your time, for sharing with us your knowledge and your experience. And I wish you a good day. Thank you very much. And for the students, we will come back at 12 o'clock with another speaker, another guest.
Thank you very much. I hope I can be one day in person teaching with your academy. It has been a pleasure. And thank you very much for inviting me.
Thank you, Professor.
Bye-bye. Bye-bye.